It was something that we just worked with her on through the years. It's one of those kind of things we call character development. Kids would point out, ask questions, but we just worked with her on how to handle that. So I think it's been a defining moment in her life, but we didn't let it traumatize her to that extent.
All right, let's talk about this one. Most people assume that when a child is bitten by a dog and the insurance pays out, the parents just sign and collect. When the child is a minor, none of that money means anything until a judge signs off. In 2012, Whitney Raines' 3-year-old daughter was attacked at a friend's house, rushed to the emergency room, wounds infected, admitted to Dell Children's. Plastic surgeons said wait and let the scars develop before deciding anything. So the family waited. Whitney spent those years raising her daughter and working 20 years as an insurance adjuster. On the other side of cases exactly like this one, when her daughter turned 17, she walked into court with no personal injury attorney and a deal she'd negotiated herself. What the judge had to decide was whether it was enough.
We are on the record in D1GN 26-2123, Raines versus Brybieska. I would ask those present for their appearances for our record, beginning with the plaintiffs, who are Whitney and Justin Raines. Ms. Raines, you're here representing yourself today, correct?
Correct.
And Mr. Raines is sitting with you in the room, correct?
Yes, Your Honor.
Okay. So then for the defendants.
Yes, Danielle Ross on behalf of defendants.
All right. And Ms. Jessberger, you're here with Arcadia Settlement Group?
Yes, Judge.
All right. And Mr. Page, if you'll make your appearance, please.
And I'm Scott Beige, and I'm here representing minor plaintiff ER.
All right. So I assume we're going to want to elicit some testimony from Ms. Raines.
With the court's permission, I'd like to have both Whitney and Justin Raines both sworn in.
Sounds perfect. If y'all will both please raise your right hand for me. Do you solemnly swear or affirm that any of the testimony you'll give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Yes, ma'am.
All right. Thank you very much. Who would like to, Mr. Bade, would you like to go forward with questions?
I volunteer, Your Honor.
Okay. How about
With the court's permission, I'll start with Whitney. Would you please state your name?
Whitney Raines.
And Ms. Raines, you understand that we're here today for the court to consider a settlement that was reached on behalf of your daughter, and we're going to refer to her by her initials, ER, for a personal injury she received?
Yes, sir.
And that happened quite a while back. That it happened, according to the original petition, on November 25th, 2012. Is that
That's
correct?
Yes.
And the name of the defendants are very difficult to pronounce. Were those your friends?
Yes, Roxy and Michael Brybieska.
And you were over there at their house, and at the time, your daughter, ER, was approximately 3 years old?
Yeah, I believe so. She was. Yes.
And she was unfortunately bitten by their dog.
Correct.
And after the dog, your profession is that you are an adjuster, insurance adjuster. Is that right?
For the last 20 years, yes, sir.
Okay. So you took her to the doctor?
Correct. We went to the ER first, and then we saw our pediatrician the next day, and she was, the wounds had gotten infected. So then we were admitted to Dell Children's.
Okay.
Yeah.
And then, but that got taken care of. And then basically, after you went and saw other physicians like a plastic surgeon, but I understood the recommendations were to wait until she got older.
In Texas and across the United States, a minor cannot legally release their own legal claims. Any settlement reached on behalf of a minor requires formal court approval before it is binding. The judge reviews the injury, the settlement amount, the payment structure, and whether the minor had independent legal representation. Without that approval, no money can change hands, and once approved and signed, the release is permanent. The minor cannot sue again for the same incident, even after turning 18.
Correct. We wanted to, we treated the scars the best that we could. And then, before we wanted to do any type of remediation or revisions, we wanted her to mature since she was so little and kind of see what the scars, how they developed, And that's kind of why we waited so long to see how this will progress. Yeah.
Right. Right. And you waited until now. Right now she's, according to my record, she's 17 years old. Is that right?
She just turned 17. Yes.
Yeah. So happy birthday to her. What grade is she in high school?
She's about to start her senior year. So it's a busy year.
Okay. And up to this date, she still hasn't had any surgical correction or with regard to the scars.
We went to a plastic surgeon, I think it was last year, I believe, and that's when we got some consults because we had visited with a pediatric plastic surgeon early, like immediately after the aftermath of everything. And so we went to a new plastic surgeon just to get, an idea of what they could do at this point. I don't remember when that was. That was late last year. After talking with ER and asking her if she was ready or wanted to do anything about them. So that's
and she's been, and not downplaying them, but she's been able to go to school with them and be go to school and be an active student, and she makes really good grades at school, correct?
She does. She's very good student athlete. She's on the dance team and has excellent grades and a promising future.
And so it's going to be up to you and her, and y'all are going to maintain your insurance. So if she chooses to get corrective procedure, she'll be able to get it.
Correct.
Okay. So then you made a decision that it was time to try and make an investigation on your own to try and resolve the case.
That is correct.
And this is not a confidential settlement. You obtained a settlement in the gross amount of $300,000 on her behalf from the homeowner's policy of the defendants, and you chose to have the Arcadia people do an annuity for your daughter, which is really great. And I'm going to go through that with you on the record. Because your daughter is college bound, it's set up to have her receive $19,250 payable semi-annually, guaranteed for 4 years, beginning on 7/1/27, with the last guaranteed payment on 1/1/2031. And then on top of that, she's going to receive lump sum payments at age 18 on 6/30/2027 of $10,000. That's when she's 18. And then when she's 25, she gets $50,000. And when she's 28, she gets $50,000. And when she's 30, she gets $170,134.92. And that's all set out in the judgment for the judge to see. And it's quite a good return on this structure when you consider that she's 17 years old. So in particular, that second part of the structure, we got quite a good return on that money. Is that a correct statement of the structure, and do you approve of that structure?
As I understand it, yes, and we do approve it.
Okay. And I appreciate the fact that you and your husband wanted to do that, because I think that sets up her education, but it also sets up lump sum payments when she's older and more mature, when she can use that to pay back any student loans should she need them. And also take care of other things that maybe she might need, like a house or things of that nature. But she's basically, since this happened back in 2012, she hasn't shown any signs of trauma or anything like that at this point in time, and she's leading a normal life.
It was something that we just worked with her on through the years. It's one of those kind of things we call character development. Kids would point out, ask questions, but we just worked with her on how to handle that. So I think it's been a defining moment in her life, but we didn't let it traumatize her to that extent. But it's it's something that she still has to kind of explain, but she's very good at makeup as most teenage girls are these days. So she's very good at concealing the best she can. But yeah, I think she's had a good recovery from it.
So you feel comfortable with this settlement? You think it fairly compensates her for the injury?
Yeah, and we talked to her about it and wanted her blessing. So she's ready to get this behind her. And yeah.
You understand if the judge approves this that she will never be able to go back against Michael and Roxanne. How do you say their last name?
Bribieska.
Berieska, or their
Mm-hmm.
or their insurance carrier, the Hartford or Sentinel National Company, or anyone else for what the unfortunate incident that occurred on November 25th, 2012. Correct?
Yes, understands that.
You guys, okay, and you feel like you've been fully informed and you understand what is going on here, and you don't need the aid of an attorney, and you've had an opportunity to ask me any questions you might have with regard to the case.
Yes, sir.
Okay, and do you have any questions today?
No, sir.
Okay, and knowing all that, do you believe that this settlement's in the best interest of your daughter, ER? And I don't mean to refer to her as ER. She's a wonderful young lady, but I just on the record,
Yes.
do you believe it's in her best interest?
Absolutely, yes.
And are you asking the court to adopt the settlement and to sign the agreed final judgment approving it?
Yes, sir. Please. Thank you.
Okay. You understand this is the end of the case, right?
Completely, yes.
Okay. Okay. That's all the questions I have.
The Raines family isn't the first to bring a minor's personal injury case to court for approval. Here are 3 documented situations showing how courts handle these settlements and what happens when they don't approve them.
Ms. Ross, do you have any questions for Ms. Raines?
Yeah. I actually, not for Miss Raines. I just was going to duplicate the same for Mr. Raines, if you don't mind.
Sure. Mr.
Yeah, if you'd
Mr.
like to
Raines,
go.
if you'll come a little bit
Yeah.
closer to the mic, to whatever microphone there is there.
Justin, you sat here and heard the testimony of your wife, Whitney Raines, correct?
Yes, ma'am.
And you would agree with the testimony there?
100%. Yes, ma'am.
Okay. You don't have any differing understandings or opinions other than the testimony that was currently given, correct?
That is correct. Yes, ma'am.
Okay. And just for the record, you are not bringing or seeking reimbursement, and you understand that you are not seeking any reimbursement for medical care, correct?
Yes, ma'am.
Okay. And that and ER also understands that this is all she's going to get, regardless of when she turns 18 or not. She cannot bring her own separate suit.
Yes, ma'am.
Okay. No further questions.
Mr. Page, do you have any questions for Mr. Raines by chance?
Gee, those were the questions I was going to ask Mr. Raines, so I have no other than say good morning, Mr. Raines.
Okay.
Nice.
I just have a couple questions, not so much for the Raines, but Mr. Page, I'm wondering, did you have a chance to meet with ER individually as well?
Well, I had a chance to look at her pictures. I talked with her mom when she was always at school when I talked to them. But I know from looking at the medical records and looking at the pictures, she's done very well at school, and I feel real good about the case, Your Honor.
Sure. And Ms. Raines, just to reiterate, I know you already have told us that you've talked about all of this with her, and she has given her age, I want to make sure she has a good understanding of what all this is about. And so I trust you've had those conversations with her and she's in full agreement with today.
Absolutely. I mean, she has the benefit of, me talking to her over her lifetime of me being in this position on the other side, being on the insurance side, and explain to her, the aftermath of accidents and things. And so, yeah, she's fully informed. And, when we were planning out the structure, we talked about what that meant and, what that would do for her future. And, it's opened up doors for her because she has desires to go to some pretty expensive schools that, we weren't quite prepared for. So she's very happy that this is going to provide that for her. Yeah.
Okay. All right. Well, I've heard what I need to hear to approve the settlement for your daughter. And I did review the judgment. Mr. Page, I see your fees are taken care of in here. And the amount is included. So that would be my other box to check. And I assume it's got all of the language needed for the annuity company to effectuate what's been spelled out in the judgment.
Yes, Your Honor. We had it ran it by the annuity company before we submitted it.
Okay. Well, then I will approve the settlement and I will get this signed and dated today and entered so that y'all can put away this chapter. And good luck to you both. And especially to your daughter. I hope she does really well. And thank you all for working together on this.
Yes, ma'am.
Thank-
Thank you.
Thank you, Your Honor.
Thank you, Judge.
We can go off the record. I'll take care of this straight away.
Okay.
Thank you.
Thank you so much.
Y'all
May we
are
be
all
excused?
excused.
Here's what most people don't know. A settlement for a minor isn't final just because the family agrees to it. The court reviews it independently, the structure, the amount, the long-term adequacy, and can reject it even if everyone in the room signed off. This one held up because Whitney spent 20 years on the other side of cases exactly like it, and she used every bit of that experience. The judge didn't just approve the number, she approved the timing. The fact that this family waited 14 years to let the injury fully show itself before anyone put a value on it. And when Whitney's daughter is asked about it now, her answer isn't a lawsuit story. It's what her mother called character development, learning how to answer a question from another kid without ever letting the answer define her. So here's the question. If it were your child, would you have waited that long to settle or moved faster? Drop it in the comments. If you want more cases like this, subscribe and stay tuned. Next one is worth it.